Hello, everyone. I'm very happy to do a presentation today. This presentation is mainly about a recent ART win by Team 2. And I'm going to use this case as an example to share some of my thoughts about how to raise a legal argument and presenting the evidence to not only the tribunal, but also the department in the visa application. And just share you guys about my thinking procedure while managing this matter. So let's start. This is my introduction. This is the objectives of this session. Understanding the legal framework, just a quick brief about the legal framework for this case, and about the real scenario and the case-based learning exam. So when we're talking about the legal thinking, client comes to approach you saying that I want to apply for a visa, and you check the visa requirement and you want to prove the client meet the requirements. You must raise a legal argument. I put 3 steps for making a legal argument. So the first step is, what's the relevant laws? The laws can be a section in the act or regulations or the policy, the PAM, and any case laws. The second step is, what's the fact? So fact is basically the story of the client scenario. It's called a fact. So step 3 is, what kind of evidence the client had to support the fact. So this is basically the 3 steps I'm gonna use in making a legal argument. And also in practice, sometimes the client comes to you with the facts saying, okay, this is my scenario, what I can do. So if in that case, we just simply switch step 1 and step 2, because you have the fact first and you're just using the fact to find out what's the relevant laws, and the step 3 will be the evidence. And I think most of you, because most of us, we learned from the law school that there's a thing called ARIC, right? Issue, rule, application, and conclusion. But at law school, we just stop this at the application. We don't have another further step relating to the evidence. But in practice, the evidence is the most important thing. And only with evidence we can prove the fact and apply the fact to the law. So that's the basic concept. So if we want to make a strong legal argument, it must contain laws, facts, and evidence. That's the basic part, the theory. The theory part is done. Let's go to the case. Team 2, the recent win. So just give you a very brief background of the case. So the client, she was granted a 189 PR visa back in September 2017, which is 8 years ago. And in that 189 visa application, the client claimed to have a de facto partner and included the de facto partner into the 189 application. However, the relationship is fake. If you guys have some knowledge about the 189 visa back in 2017, you will know the partner will not give the primary applicant any extra score. They will give the primary applicant some 5-point extra score only if the partner have a skill assessment and language. So a single applicant won't get a higher point. So that's the law back in 2017. The client included the de facto partner into the application, and the partner didn't claim any points. So basically, whatever the client has the partner or not, the invitation points are the same. Then in the application, in the 189 application, the so-called agent, because the agent then is not a registered migration agent and not a lawyer, just a random people. He altered the address on the application's phone bills and the bank statements into a fake address, and they make a claim that the address is the place the applicants and the fake partner lived in. And also the agent forged my client's signature on the Form 80. And basically the contents in the Form 80 is not accurate. And forged the applicant's signature on a faked lease agreement. Then, in roughly 2021, the 189 visa was canceled because the department found out that the applicant, my client, provided a fake phone bill and a bank statement in the initial 189 visa application. And yeah, they just say, so they canceled the 189 visa, saying that this bogus document provided in the initial application and is a non-compliance. And before because the applicant was unsure at that time, so yeah, she received a NOIC, notice of intention to considering cancellation first, saying that her visa gonna be canceled after 14 days or something. And yeah, so the applicant, she applied for a 155 visa before the actual cancellations took place. So this is a strategy or tricks we can use in similar scenario. Is before your PR, if a person's VR is subject to cancellation, before the cancellation happen, the person can apply for a 155 visa. And for the 155 visa, if you go through to the Schedule 2 of the 155 visa, you will see the 155 will be granted, even if the department find out there was a bogus document provided in the initial PR application. But yeah, make sure that everything in the 155 application is genuine and correct. So the 155 will be granted, and the department will cancel the previous 189. Or even the department cancel the 189, the 155 will be granted anyway. So the client used this strategy in 2021, and yeah, the 155 got granted, and 189 got canceled. And after 3 years, so October 2024, the 155 visa was canceled again due to the same reason. And so this tribunal review is an application review for this 155 visa cancellation. So this is a visa cancellation matter. And if you guys have a look at the visa cancellation procedure, you will find that the decision maker needs to make a 2-step decision. So first, they need to confirm whether the grounds of the cancellation exist. So in this case, the grounds of the cancellation is the previous non-compliance, which is providing incorrect information in previous visa application. So the relevant facts for the grounds is that the applicant first, she knew the fake relationship. And although the applicant has no knowledge about bogus document because the alteration is made by the agent, the applicant, she didn't know how the agent altered the documents or whether the agent altered. But it's with the applicant, she has a obligation to make sure all documents are correct, and she didn't take any reasonable steps to check the visa application form, all the documents provided to the department. So although she had no awareness about the alteration, but she do expressly give consent to the agent to fraud, but implied that the agent can do whatever he like. So basically, for this part, we can't make any argument to saying that the grounds of the visa cancellation doesn't exist. So we accept that, and we didn't make any efforts on this part. So the next step, when you're considering when decision maker consider a visa cancellation, the first step is the grounds of the cancellation, it exists, and the second steps for the consideration is whether to cancel the visa or not. And this is listed Regulation 2.41, regulations. And this is also, we said that the cancellation power is discretionary power, because the decision maker, he or she needs to consider all these 10 elements and to make a decision to cancel or not cancel. These 10 prescribed circumstances is the main arguments we're gonna make, and it's the main efforts we do in this matter. Yeah, so we have a look. You can have a look at these 10 prescribed circumstances, because some of them, the circumstances is not relevant to our clients, and some of them may have disadvantage to my client. So we just ignore that. But yeah, there's some circumstances which is relevant to the case and may help our clients to win the argument, to make the argument, and let the decision maker to make a favor decision. So I mark this as star. So you can see, have a look, for example, the sub-regulation D, the circumstances in which the non-compliance occurred. Subsection E, the present circumstances of the visa holder. And sub-regulation K, any contribution made by the holder to the community. So yeah, then we're gonna make legal arguments based on these three circumstances. And also, there's also some policy consideration related to the non-cancellation, cancellation or not. I'll just list this here. You guys can have a read, but some of the most of the policy consideration have a quite similar to the scenarios here, the current circumstances and the hardship. So yeah, we just quickly go through for that. Okay, so that's the argument we're gonna make. So first, the loss here is that the circumstance in which the non-compliance occurred. This is, according to the regulation, this is the circumstance of a decision maker must consider. And according to the law, we find out we need to talk with the client to find out any fact which can help our clients in this scenario. So here, we found out that the client said the agent didn't share the application process to our client. So she didn't know there was an application form there, and she didn't know when the visa is lodged, when the visa is granted. In order to support this claim, the clients provided some evidence. And for example, the email and the messenger communicating with the agent, and an email to the department asking for whether my visa gets granted, because the agent didn't. Basically, the agent disappeared after lodgement. And yeah, so this kind of evidence has supported the fact saying that my clients didn't have sufficient information and knowledge about the visa application. And the second fact related to this is the agent forged the signature. And in order to support this claim, this fact, the client, she did foreign examination report showing that the signature on the form 80, which provided to the department, is not signed by my client. And the reason we're using these facts to make this argument is we want to show the tribunal that my client is a victim of a crime or whatever improper conduct. I know the department, the tribunal, they may think because you agree, they implied give consent to provide this fraud or whatever. But we're trying to say that my client, she is not 100% innocent, but she did provide this misleading unconsciously. That is what we're gonna argue in this part. So we can see this argument, it includes the law and the relevant facts and the supporting evidence. So next part, this is about the present circumstance of the applicant. And this will be the more persuasive argument we're gonna make. The relevant facts in this part is all the family member of my clients, herself, her brother, older brother, and her parents are living in Australia, and all of them are PR or they didn't. So this will be a fact, and just simply supporting this fact, so we're just providing everyone's passports or ID as evidence. The second fact related to this is the parents need my client's support. This support is not only emotion support, but also health support, because my client's parents, the father had suffering a heart attack, I think, several years ago, and it's a long-term care, and the mother recently got broken her legs, so the parents needs my client's care and support. This is the facts, right? Because we need extra evidence to support that. So we collected the parents' medical reports, not the father's, the mother's, and there's evidence I didn't list here, because as I said, my client had an older brother. He is also an Australian citizen. So we also need to prove that why brother not able to be the carer. So we also provided some evidence showing that the brother is working on a full-time position, and basically he works, I think, 50 to 60 hours per week, and he has two dependent child to take care. So that's some extra evidence to support that my clients will be the only person who can provide medical support to their parents. The third fact is about the Australian child. And yeah, because my client says she is single and she doesn't have a child. So we're trying to use the nephew. My client's nephew is the older brother's son, one of the older brother's sons, to add the Australian child, minor child. And yeah, the story here is my client's brother got divorced before, and the child is with his ex-wife. And yeah, because the broken off the relationship, the child's father and the child's mother, they didn't talk a lot. And the child's nephew was living with my client since he was 2. They lived together, and my client provided a lot of support to the child and also be a bridge between the child's mother and the father when they're separate. So basically, the child's strongly rely on my client emotionally. So this will be the fact. So in order to support this claim, I initially trying to let the child, because the child is now 15 years old, so trying to let the child to be a witness. But since the child is under 18 and the child's parents don't want to do so, so I just suggest them to whether the child is willing to take a video, make a speech saying that my auntie is the person I want to live with, and I want to let my client to stay in Australia. Yeah, and we presented this video at the hearing, and the tribunal member accept that. So this will be the third fact and the relevant evidence we provide. And the fourth fact is a fact we want to raise this fact, but we failed. The reason is we don't have sufficient evidence to support. This fact is called the education and the employability in Australia. Because my client, she was Chinese nation. She had her bachelor study in China, undergraduate study in China, and came to Australia to study a master course. And then working in Australia since 2017 something. Yeah, working in Australia as a mortgage broker. And yeah, we're trying to make an argument saying that because considering my client's age, and she has never been working in China, and her qualifications and the employment itself is only happening in Australia. And in China, we don't even have an occupation called mortgage broker. So I'm trying to argue that the employability for the clients in China will be very low, and this will be a factor the decision maker need to consider. And we provide supporting evidence such as the reference letter in Australia and the qualifications in Australia, showing that the employment here is true. But our argument is my client is not able to find a job in China, and we don't have any evidence related to this action of looking for a job. So the member mentioned this in the hearing, saying that you don't have any evidence saying you have attempted to find a job or you have seeking any job back in China. So the member will not consider this as a persuasive or valid argument because of lacking of evidence. So basically, this argument was failed. And the fifth one is quite similar because the client herself has some health condition, and she is currently undertaking a treatment in Australia. And our argument is that if the client was left Australia and go back to China, she may not be able to get a health insurance or get a proper treatment. Because of lack of evidence, we don't have any attempt to seeking a doctor in China or seeking a health insurance in China. And so we failed this argument. So for this, we can see that a decision maker, tribunal member, they will not accept the argument without any evidence. So even if this will be a very good points of arguments or the fact is strong, but the evidence is sufficient. So this is the about the current situation. And next one is about the community contribution of my clients. And my clients, the fact is have two. She has two kind of community activities. So first, she was a member of a NGO, non-profit organization, and my clients is keep donation and attending the meetings and attending the activities. So we have the donation records and the supporting letters. And this happens before cancellation action. So sometimes when we say donation, I know a client, he received a NOIC, and he never do any donation or community service before, but after receiving the NOIC, he started making a donation regularly. But this may be, the member, they may say you just do this on purpose. But for this, my client has a long-term donation history and activities. And the second effect for that is my client is a member of a sailing club. Yeah, such like a sailing, it seems like a sailing club. And one of the member of the club passed away in last year, I think. This member called Vincent. He is known as the Blue Man in Sydney. Always had a show in Melbourne and Sydney. My client, as a member of the club, she just also making donation and helped the Vincent and Vincent's family to communicate with lawyer in Australia or seeking compensation. So this will be the second actions or facts my clients did in relation to the community contribution, and we have evidence. So the tribunal member accept that. Yeah. So basically, when we're making a legal argument, the legal argument itself, it's not for the whole picture. It's just for a single point under the laws. And we can see when we made a successful argument, so we put this onto the scale, and the decision maker will consider this as a weight to not cancel the visa, make a decision in favor of our clients. In such a case, our role is we trying to make an argument this, and put this little weight into the scale and let the decision maker to make a final decision. Yeah, I think that's pretty much for me about the presentation. Have you guys have any question?
I guess when it comes to like the cancellations, there is a case law about how the decision makers should give weight or less weight. Giving weights, there's a case law about this. Do you know what I'm talking about by any chance?
Yeah, I know. The weights. Yeah, this is another thing. Probably I'm not confident with. It's about the weight, because when I trying to for example, the family ties and the employability or whatever. When the decision maker make a decision, he just say I give significant weight or great weight or what a kind of weight, but this is just a wording. How the significant weight perform in this decision, that's the thing I'm not really confident with, because when we talk about the non-compliance, which is a significant weight for canceling, right? But for the family, it's a significant weight to not cancel. But which one is weight is much heavier, weight more? Just totally rely on the decision maker, right?
Yeah. So except for the 5013C, was it 3A? Like the mandatory cancellations, majority of the cancellation powers are discretionary. And again, majority of the elements, it involves an exercise of statutory discretion. Yeah. So the decision maker may cancel the visa, right? So a perfect example of this is today you were talking about Section 109 cancellation with incorrect answers and provision of maybe fabricated documents.
Yeah.
But Section 116 cancellation, which is what we call a general cancellation. General cancellations may happen with breach of visa conditions and breach of visa conditions, or the circumstances of visa grant may no longer be valid.
Exist.
Yeah. So for example, if you and your partner, if you are and your partner holding a 482 visa, but if you separate, then the secondary applicant obtained the 482 visa no longer meets the eligibility criteria, which actually was simply the relationship. Then the secondary visa holder's visa may be cancelled, right? But the same cancellation powers may extend to a partner visa, a permanent partner visa, 820 and 801. If the sponsor and the visa applicant or the visa holder is no longer in a relationship, how come immigration doesn't cancel the partner visa holder? And they have every right to under Section 116. But immigration decides not to, because it's a discretionary element. And under policy, they actually even talk in the policy as well. They just goes, it's not part to do so. So I guess what I'm trying to say is discretionary. So then how do you decide whether to cancel or not? So the discretion to cancel, and this is case law is Cockrell, Cockrell, and MIAC 2008. Cockrell. Cockrell's case really talks about when a case officer or decision maker, I should say, is trying to exercise their decision to cancel or not. So a discretion to cancel should not be deciding whether not to cancel a visa or not. So we're not going in favor of the applicant. So when we look at the cancellation, so it should be talking about give more weight in favor of the applicant. So you should never conclude it in that way. You should always conclude it in that the weight should be given against cancelling the applicant's visa. Like that should be the correct terminology. So that's and the principles and the theory behind it, you'll find it in that case, Cockrell. Yeah, so whenever you're drafting a submission, you should never write, or it's not proper to write that the more weight should be given in favor of the client. You should never write it like that. Again, it's got really nothing to do with your topic, like the evidence and all this, but just general about the cancellation. When you're dealing with cancellation cases, majority of the cancellations that we deal and you'll probably deal with is discretionary, and the case officers do have the power to cancel or not. And because of this, whenever you get a NOIC, because of the nature, whenever you get the NOIC, you have to understand the psyche of it. Immigration have only begun the cancellation procedure simply because, number one, they feel that they have sufficient information to cancel your client's visa. And number two, because of that, the department is already there. They are gonna cancel your client's visa. So with the department, because they've initiated through the NOIC, it's the psyche of this whole application is already in the department's or against the client's favor. Yeah, because they wouldn't start this whole exercise if they didn't want it to.
Unless maybe you have some new facts which the department doesn't know.
Exactly. Yeah. So another thing, whenever the cancellation happens, and if you appeal the cancellation and if you're successful, the tribunal does not remit the file back. They set aside the minister's decision to cancel your client's visa. And the main difference, setting aside and remit, is it all stops there. So setting aside the decision pretty much simply means that the cancellation never happened. So your client was never unlawful. Your client have held the bridging visa E, but it's never really been effect because your client's visa was never cancelled in the past.
Yeah.
One thing that really could also cause trouble is, what if the department cancelled a client's visa and my client's visa was supposed to expire in June, but it's already September because of the review processing, and we have triumphed and successfully argued the case, and the cancellation never took place. Because the cancellation never took place, that means your client's visa had expired when it was supposed to expire, which was in June. So that brings up a huge issue. That means that your client is now unlawful.
Yeah, that's true.
Because of that whole procedural legal thing. And this is why when you look at a number of Schedule 1s of number of visas, you will see some provisions in Schedule 1 that allows you to still make a valid application for a visa, such as a graduate visa, where it goes, if you've had a student visa cancelled and if you've successfully won at the tribunal, there's a bit of a provision. So that's to cover this type of unfavorable situation. May have started simply because of a case officer who's had this bloody mission of cancelling your client's visa for whatever the reason it may be. So the cancellation in itself is very problematic, but even if you do successfully defend and win back the cancellation, that could also have further consequences. So you also need to be aware of those. Okay. Again, thank you, Tony, for sharing your knowledge and insights.
Thank you, guys.